I'd like to take a brief moment just to ask each of our panel for their key takeaways or their final thoughts from today's presentation. Richard, we turn to you first. Perhaps you want to give us a few of your closing thoughts from today.
Sure. So as I mentioned during my presentation, that when I go through all of these cases that are making decisions as to whether or not an operating agreement is considered executory or not executory, that I just feel as though many of the courts are result oriented. They've already determined why it is that they're ruling, but so they kind of justify it by coming up with their analysis of certain provisions in the agreement that will render that agreement executory or not executory. And I think that the same facts, whether the same facts considered by a court in one state or before one bankruptcy judge will be ruled upon one way and ruled upon differently by a judge in another bankruptcy court. So it's really important to read through the cases that are in the materials and others that cite to those cases, and just realize that notwithstanding a holding in one particular court, that there's a very good chance that your judge would rule the opposite way, given the same exact facts and circumstances.
Thank you so much, Michael. We turn to you second. Do you want to give us a few of your key takeaways from today?
Sure. I think first is when you're drafting special purpose LLC operating agreements, just being mindful of the restrictions that are set forth therein, the rights provided to lenders, and especially the rights and restrictions on the independent manager provisions, keeping in mind that you don't want to overreach because that will bring up federal preemption concerns and possibly void the provisions as a matter of being against federal bankruptcy policy. And so I think careful drafting from both lenders and borrowers in those situations can really provide the impact or what's intended by these provisions, which is bankruptcy remoteness, not bankruptcy proof. With respect to golden shares and the use of equity, if it really is an equity investment, I think lenders have to be careful that it doesn't look like it's tied to the debt. That is, that the equity will, and the rights thereunder or in relation thereto, will continue beyond the repayment of the debt, and that there's a significant equity investment, and it's not just a magical, quote unquote, golden share that allows the lender to prevent a bankruptcy filing. And finally, for opinion givers, people that are dealing with the authority to file opinions, they just also have to be mindful of these types of transactions and the provisions related to both equity investments by a lender or creditor, as well as the restrictions on independent managers and bankruptcy votes.
Thank you so much. Finally, Stephen, we turn to you. Do you want to close us out with a few of your key takeaways?
Sure. My key takeaway from this presentation is that the bankruptcy code is not a fix-all solution that can be used to avoid limitations placed on LLC governance under state law and the LLC's operating agreement. This is not surprising because bankruptcy courts generally enforce restrictions on corporate governance in the corporate context as well, either through the business judgment rule or exculpatory provisions and the demand requirements. There's plenty of examples where courts enforce limitations on corporate provisions, and I don't know why these, why the treatment of LLC limitations should be any different. I'm not convinced that LLCs and corporations are truly different enough to warrant a different result. But that issue is one for the Delaware legislature, not the courts. And the courts had acknowledged consistently that the Delaware legislature has provided for this additional limitation power in LLC context and not in the corporate context, and they have deferred to that decision and treat the entity separately just the same. Barring a change in state law, I think bankruptcy trustees and creditors committees will continue to face significant obstacles in their pursuit of fiduciary duty claims against managers of an LLC with a properly drafted fiduciary waiver provision.